Welcome, good evening members. So this is a conveyancing session, and in this session I want to deal with a substantive approach on how you convert sub-leases to sectional properties units. And before we begin, it is important for us to understand the historical dimension, or briefly, just in a brief manner, to know the differences that existed in the previous regime to the new regime. And the starting point is on the recent notice that was issued on the 9th May 2021 by the Ministry of Land that notified the public that long-term leases prepared on the basis of architectural plans will no longer be registered with effect from 10th May 2021, and further that the Lands Registry shall no longer register long-term leases for units. So this runs contrary to the provisions of Section 54(5) of the Land Registration Act, which mandates the registrar to register long-term leases and to issue certificate of leases over units. So the current law and procedures for transition remain unclear, given that regulations and guidelines are yet to be finalized, and the Land Registration Act has not been amended where long-term leases are concerned. So remember, this was a block that was done before the incorporation of the new Sectional Properties Act together with the Sectional Properties Regulations. So I want us to understand the difference between the two via a blog that was written by Professor Albert Moma and Company Advocates on July 2021. So they decided to give a transition on the sectional properties vis-a-vis the older Sectional Properties Act of 1987. And this is a critical starting point. So the promulgation of the Constitution of Kenya 2010 culminated in the complete overhaul of Kenya's land regime, leading to the enactment of 2012 land laws. So the latest addition to Kenya's land regime comes with more than 8 years later with the repeal of Sectional Properties Act of 1987 that was on 28th December 2020 replaced by the Sectional Properties Act of 2020 to bring it into alignment with the provisions of Kenya's 2010 disposition. So the first key difference between the two was on residue term. The Sectional Properties Act of 1987 that has been repealed applied to leasehold properties with unexpired residue terms of not less than 45 years. Under the provisions of the Sectional Properties Act of 2020, this term was reduced to now 21 years. Okay. Then if you check on certificate of title or certificate of lease, the provisions of the old Act provided for the issuance of title deeds for sectional properties with respect to each unit. But the new Sectional Properties Act now made provisions for the issuance of a certificate of title or certificate of lease. Additionally, the title is now to include the unit's proportional share in the common property. That was the first distinction, the second distinction rather. Then you go to the conversion to units. Long-term subleases conferring ownership of apartments, flats, mansionettes, townhouses or offices registered before 28th December 2020 must conform to Section 54(5) of the Land Registration Act within a period of 2 years. And such conversion may be initiated by a developer, a management company, or an owner of a unit. If the conversion is not effected within the prescribed period, the registrar shall register a restriction against the title to prevent any further dealings on it by the proprietor or developer. Then, on the other approach is on institutional manager. The older Sectional Properties Act 1987 mandated the appointment of an institutional manager to manage the units. This is where we had the common property and both the movable and immovable property of a corporation. But under the new Act, the corporation may ensure the property is well managed, including through the management of services of a property manager. And the powers and duties of the corporation are subject to any restriction are performed by the board of the corporation. Disposition of common property and exclusive use areas. So the previous Act allowed the disposition of common property or any part of it either through a transfer or lease agreement. But the provisions of the new Sectional Properties Act, however, prohibit corporations from making bylaws that permit material changes in the use or density of the common property without the prior approval of the relevant county government. Such bylaws have no force or effect. Additionally, subject to a unanimous resolution, if permitted by its bylaws, a corporation may grant a lease to an owner of a unit for an exclusive use of an area or areas of the common property. Then when it comes to termination and dissolution of corporations, under the older Act, the sectional status could be terminated by unanimous resolution. Additionally, there was a requirement for an application to be made to court by the corporation, owner of a unit, a registered judge, or a purchaser under an agreement for sale. And this requirement has been done away with under the Sectional Properties Act of 2020. In addition to unanimous resolution, the sectional status of building may also be terminated by substantial or total damage to the building or by compulsory acquisition under the provisions of the new Act. Okay, the new Act has decided to add, apart from the unanimous resolution, the sectional properties status may be terminated by substantial or total damage to the building or by compulsory acquisition. The effect of termination of the sectional property status is the automatic dissolution of the corporation. Then limit on security deposit, because the 1987 Act provided that the amount the developer may charge the purchaser as a security deposit in respect of the unit was not to exceed 1 month's rent, but the new Act does not contain any such caps, meaning that a developer is at liberty to charge a security deposit if a purchaser opts to rent a unit prior to receiving the title. Okay. Georeferencing of sectional plans. Every plan lodged for registration as a sectional plan under the provisions of the new Act is to be georeferenced. In addition, the new Act permits the use of technology by corporations in the execution of their duties. This is a shift from the previous regime. Cautions in respect of unpaid amounts. So corporations may register cautions against the title to an owner's unit for any amount that they may be due or unpaid, provided that the caution will be withdrawn within 90 days of payment. Notably, the repeated Act was silent on the period within which the caution should be withdrawn. That is notable. Investments. The provisions of the new Act mandate a corporation seeking to invest funds not immediately required by it to obtain an endorsement through a special resolution. Okay. Internal dispute resolution. The Repeal Act required that certain disputes be resolved by the Landlord and Tenants Dispute Tribunal established under the Landlord and Tenants Act. Under the new Act, disputes relating to contravention of bylaws are referred to an Internal Dispute Resolution Committee. So this is a big shift. The committee may hear and determine disputes without any limits as to the penalties to be levied. And when it comes to appeals, the Sectional Properties Act that was repealed barred any right of appeal from a ruling of the tribunal except on matters of law. Okay. The provisions of the 2020 Act, however, makes provisions for appeal of decision of Internal Dispute Resolution Committee to the ELC court. That is critical. Okay. That is very critical. You appeal the decision of the Internal Dispute Resolution Committee to the ELC court. Okay. Because the previous 1987 Act barred any right of appeal from a ruling of the tribunal. Which tribunal? The Landlord and Tenants Dispute Tribunal. Okay, that is critical. This was the starting point, so that when I'm analyzing the various documents required in the conversion of long-term leases into sectional units, now you understand the basis of why we are doing these conversions. Okay. The conversion of a long-term leases into sectional unit is a critical process under Sectional Properties Act 2020. Okay. The legal basis for conversion was seen in Section 13(2) of the Sectional Properties Act that empowered the registrar to convert long-term leases into sectional units in accordance with set regulations. And the objective was to bring all properties that met the threshold on apartments, flats, mansionettes, townhouses, or offices into conformity with the sectional property regime, thereby enhancing ownership rights, simplifying transactions, and securing interest. And what are the circumstances under which conversion will arise? Conversion is mandatory or permissible where the following happens: where all units have been transferred to individual owners and the reversionary interest, being the freehold or head lease title, has been transferred to the management company to hold in trust for the owners. Okay. 2. All units have been transferred and there is a written agreement to transfer the reversionary interest to the management company. 3. Some units have been transferred and there is a written agreement for the transfer of the reversionary interest to the management company. These scenarios contemplate ownership that is either fully or partially distributed to individual lessees, with the residual interest vested or to be vested in a corporate entity acting on its behalf. What is the application procedure for conversion? So applications are to be made using Form SP 16 prescribed in the first schedule of the Sectional Properties Regulations. And the management company is the principal applicant in this case, while the responsibility initially lies with the developer. If the management company or developer fails to apply, individual owners may step in and apply directly. Where the original title is encumbered, the application is routed through the chargee, e.g. a bank holding a charge, who will forward the title to the registrar to allow issuance of sectional titles with corresponding encumbrance being noted. Importantly, failure to comply for conversion does not invalidate existing securities such as charges. Okay. Then it's also important to take note on the registrar's role and discretion. The registrar may dispense with production of the original title in certain instances, especially where the developer or proprietor is uncooperative or unavailable. And in that situation, the registrar is also empowered to publish a gazette notice calling for the title. If the same is unproduced within 60 days, they may proceed to register the sectional plan and issue unit titles. A restriction may be registered on the parcel to prevent further dealings if there is non-compliance. What are the requirements for a complete conversion application? An application for conversion must be accompanied by the sectional plan, long-term lease or sublease, the certificate of lease, and the parcel title or a certified copy. Where the original parcel title is unavailable and not encumbered, an indemnity must be lodged per Land Registration General Regulations 2017 and in particular Regulations 27 and 28. Okay. You must give an indemnity. You must lodge the same. This is required under the Land Registration on General Regulations 2017. Then what are the conditions on sale of premises and existing subleases? No sale of premises within a building for residential or commercial use shall be effected without registration of a sectional plan that includes such premises. This is intended to curtail piecemeal or informal sales that escape regulatory mutiny. Moreover, all pre-existing long-term subleases intended to confer ownership must be reviewed to align with Section 54(5) of the Land Registration Act due to the enactment of Sectional Properties Act. Section 54(5) of the LRA mandates the registrar to register long-term leases and issue certificates of lease over apartments, flats, mansionettes, townhouses, or offices having the effect of conferring ownership if the property comprised is properly georeferenced and approved by the statutory body responsible for the survey of land. So in essence, Sectional Properties Act of 2020 came to bring effect or life to Section 54(5) of the LRA Act. No fresh stamp is payable for conversion of subleases where duty was already paid. Okay. What is the effect of statutory power of sale? If a chargee exercises the statutory power of sale over a unit, the registrar shall issue a new certificate of lease in the transferee's name upon registration of the transfer. Long-term leases exempt for conversion. Regulation 22 of the Sectional Properties Regulations list long-term leases that are exempt for conversion to sectional properties. They include 1. Where reversionary interest expressly reserved for the lessor, developer, or management company as legal owner and not as trustee. This means that where the lease agreement clearly states that the developer or lessor or a management company retains the reversionary interest in their own right, i.e. not holding it in trust for the owners of the units, then conversion does not apply. This is one of the key exemptions that you can be asked. Okay, since the intention is that the developer or lessor retains ownership, the legal arrangement does not lend itself to sectional ownership. Example can be seen where the developer leases out spaces to different tenants but retains ownership of the underlying land and structure. That is exempted from conversion. Then another exemption appears to where we have large mixed use or phase developments where reversion is retained by developer or management company. Okay. The first one was on reversionary interest where the management company or lessor or developer is the legal owner and not as a trustee. Now we can see large mixed use or phased developments where reversion is retained by developer or management company. This clause applies to 1. Large mixed use projects where you have combination of commercial, residential and retail developments. Phased developments where we have project developments developed over multiple stages and phases. And 3, where agreements provide that the reversion is to be retained by the developer or held by a management company. Conversion would complicate or disrupt the management in future phases, hence such developments are excluded, and one of the examples is a phased city project with shopping centers, apartments and offices that will evolve over 10 years. It will be commercially impractical to transfer titles piecemeal during each phase. So large mixed use or phased developments where reversion is retained by developer or management company is exempted. Then we have strategic national projects, what we call substantial transactions in special economic zones. These are policy-based exemptions covering projects of national importance, e.g. transport hubs, government-backed housing, substantial real estate transactions involving high-value or complex investment, special economic zones which are governed by specific regulations and investment frameworks. These projects have complex ownership regulatory frameworks and commercial sensitivities that make sectional conversions impractical or undesirable. A government-backed industrial park or a strategic export processing zone where private investors lease large parcels for factories or logistics, that is exempted. So it was important that we read that document through so that we appreciate how various elements and exceptions come in on board when it comes to the conversion of long-term leases to sectional units. So still on the topic of conversion of long-term leases to sectional units, I've told you on 7th May 2021, the Cabinet Secretary for the Ministry of Lands and Physical Planning issued a notice informing the general public of the conversion of long-term leases that do not conform with Section 54(5) of the Land Registration Act and Section 13 of the Sectional Properties Act. Okay. Now we are interested with the exact procedure on how you convert. Okay. The effect of the notice is that all sectional units shall now be required to have properly registered sectional plans. All sectional plans submitted for registration should be geo-referenced, indicate the parcel plans, the number identifying the unit, the approximate floor area of each unit and the use of the units. The sectional plans must also be signed by the proprietor and signed and sealed by the Director of Survey. Okay. What are the ingredients of the sectional plans? The sectional plans indicate the parcel plans, the number identifying the units, the approximate floor area of each unit, and the user of the units. Okay. And it must be signed by the proprietor and signed and sealed by the Director of Survey. That is important. For purposes of conversion of already registered long-term subleases, the owners of the property will be required to make an application in the prescribed form and attach the following documents at the lands registries. Okay, you have to attach a sectional plan, the original title document, the long-term lease previously registering the unit, okay, a sectional plan, original title document, long-term lease previously registering the unit, and the rent apportionment for the unit. The registrar may, however, dispense with the production of the original title if the developer is not willing or unable to surrender the title for purposes of conversion. Upon submission, the sectional plan will be registered and the previous register will be closed, and a new register will be opened. Lastly, this is the last document that we will have a look at when it comes to this procedure of conversion of long-term leases to sectional titles in Kenya. All the enabling provisions we have mastered. We have understood the previous section, the previous governing law person to this sector, and why we are converting. Okay. The instances that the long-term leases may be converted to sectional properties was also captured pursuant to Regulation 18 of the Sectional Properties Regulations of 2021. Okay, we saw partial transfers or full transfers, where all units have been transferred to the respective owners and revisionary interest has been converted to the management company to hold in trust, but not as legal owners. Where they are legal owners, that was not subjected to conversion. All the units have been transferred to the respective owners, and the revisionary interest is by written agreement intended to be transferred to the management company to hold in trust. Or part of the units have been transferred to the respective owners, and the revisionary interest is by written agreement intended to be transferred to the management company to hold in trust for the owners. Okay. Who may initiate? Owners, management company. Give us the detailed conversion process. Pursuant to the Sectional Properties Act, a surveyor is required to prepare a sectional plan from a building plan prepared by an architect and approved by the respective county government. This means that all sectional units shall now be required to have properly registered sectional plans. What is the source of this sectional plan? It is prepared from a building plan that was prepared by an architect and that had been approved by a respective county government. So the sectional plans are then submitted for registration having been geo-referenced. Described in the heading of the plan as a sectional plan, indicate the parcel plans, bear the number identifying the unit, indicate the approximate floor area of each unit, and clearly state the user of the units. The sectional plans must also be signed by the proprietor and signed and sealed by the director of survey. Those are the marking points. You start with an architecture. An architect prepares a building plan, and the building plan is approved by the respective county government. Then you bring on board a surveyor. A surveyor prepares a sectional plan from the building plans, and this sectional plan is submitted for registration having been geo-referenced. So geo-referencing is another mark. What are the contents of this sectional plan? The sectional plan should indicate the parcel plans, bear the number identifying the unit, indicate the approximate floor area of each unit, and clearly state the user of the units. Okay. The sectional plan must also be signed by the proprietor and signed and sealed by the director of survey. So this sectional plan is taken to the Director of Survey for sealing and signature. Upon submission of the above, the sectional plan will be registered and the previous register will be closed. On registration of the sectional plan at the relevant land registry, the owners of the units in the parcel of land must establish a corporation. The corporation is established under Section 17 of the Sectional Properties Act and not the Companies Act, as was the case in the previous regime. That was another difference. It is tasked with the management of the entire property by doing things such as maintaining the property in good condition, enforcing the bylaws, payment of premiums for any insurance policies, and all other tasks that ensure that the property is being properly managed. Okay. So after the sectional plan has been registered and the previous register closed, the owners of the units in the parcel must establish a corporation. And among the tasks of this corporation is maintenance of the property in good condition, enforcing bylaws, payment of premiums, etc. The registrar shall, within 21 days from the day a sectional plan is registered, submit to the county government of the area in which the parcel is located a copy of the registered sectional plan, where the management company or owners have initiated the preparation of a sectional plan during conversion, and where they fail to avail the approved architectural plans or the available approved architectural plan is at variance with the development, the management company or the owners shall avail an affidavit detailing the loss or inability to avail the said documents. And the sectional plan may be prepared by the surveyor without necessarily relying on the approved architectural plan. C. The county government may endorse its certificate on sectional plan without the production of the approved architectural plans based on the affidavits. So be keen there. Where the management company or owners have initiated the preparation of a sectional plan during conversion, and where they fail to avail the approved architectural plan, or the available approved architectural plan is at variance with the development, the management company shall avail an affidavit detailing the loss or inability to avail the said documents, and the sectional plan may be prepared by the surveyor without necessary relying on the approved architectural plan. And C. The county government may endorse its certificate on this sectional plan without the production of the approved architectural plans based on the affidavits. And the conversion process seeks to create a favorable environment to investors and property owners by giving them more power over the properties they own. And that was the procedure for conversion of long-term leases under two sectional properties units. Up to that point, I believe that marks the end of this presentation.